All right, so share screen. Sorry if it's a little noisy outside. Apparently people are having fun selling real estate today, so that's good. No complaints here. All right, so give me a thumbs up if you see in front of you the agreement to contract to buy, sell real estate residential. Awesome. So the first part of this is it's kind of a plug and play, right? You fill in the blanks, you got a couple definitions. So the buyer and the seller, in a perfect world, you have the full name as it's written on their birth certificate or their ID for both buyer and seller that are purchasing the contract. If they want it put in another name or anything like that, an entity, they can do so afterwards. One point of note to make here: if someone does say, "Hey, we're going to buy this in an entity, like an LLC, because it's an investment," you do want to make sure that their lender is going to allow that. A lot of times, if you are purchasing through an LLC, the lender may require you do some sort of commercial financing. So just a quick note to make on there. By the way, these notes, so pretend the class the whole time is a script, like I'm talking to you as my client, right? And I'll bounce back and forth between buyer and seller. So I'm going to pause script. Anytime you make a small note like this, or you have an ability, let's say in this situation, I'm sitting down with Jennifer and she says, "Hey, we're buying this property as an investment. We're going to have it in, Fox Family LLC." That at that point, I would say, okay, just to make sure, have you spoken to your lender to make sure that can be done? Because it's been my experience, a lot of times they may require a certain type of financing. Those small things right there not only are super beneficial, it's part of your fiduciary responsibility, and it gives Jennifer more of a vote of confidence that I know what I'm talking about. Okay, so that's the other reason is, and again, I don't tell you this because so you go out there and you win brownie points and stick feathers in your cap. It's because at the end of the day, you are representing someone in the largest financial transaction they've probably ever done, and some of them will ever do. And the more confidence that you've given them that they've hired the right person, the better. Okay.
I'm actually in that exact situation right now. I'm buying the lot next to my house,
Right.
in the name of our LLC, and it's cash, so the lender doesn't come into play. But the attorney needed, all of the LLC documents and all of the incorporation articles and all of that stuff. So make sure your clients have that if they're doing
Absolutely.
this.
Absolutely. Another to make, it's not just the lender. So when I'm sitting down with Jennifer and she says, "She's a rate," and I say, "Well, I'm paying cash." Awesome. The attorney is going to need a lot of documentation for your LLC. So just go ahead and get prepared. Your articles of incorporation. Some of them may require minutes of meetings and that sort of thing. Whatever you can get to them. So great point. All right, on the seller, again, same thing applies. In a perfect world, you take the deed, you have the name on the deed, and you basically copy and paste it into here. 9 times out of 10, you won't have a copy of the deed, right? So the next place you'll go to will be the tax records, either through the MLS. This also, and I point out many other areas in the contract, is a good opportunity for you to reach out to the listing agent. A listing agent, I'm going to be putting in an offer on 123 Main. I show in there that it says Megan Turcotte is the owner. Is that the only person on title or deed? Should I add anybody else? Right? Good. They could say, "Nope, it's totally fine." Awesome. Jennifer, I look forward to possibly working with you. I'll shoot over any more questions I have before we shoot the offer. Okay, so any time to build relationships with the other agent is a good one. All right, then we got a couple definitions of here. Party, defined as buyer or seller. Party is defined as both buyer and seller. The reason I highlight this and point it out is we have a lot going on right now with either personal properties or people helping their clients out by contributing commissions, reducing commissions, whatever it may be. First of all, that's a separate discussion altogether, but if that is a situation where you're considering doing, just let me or your team leader know, either Karen or Vince. Secondly, if you do come to an agreement where or you're going to pay for the home warranty, or it's going to come out of your commission, or whatever it may be, that does not go on this contract. This contract is between the parties, and the agent is not one of the parties on the contract, or the brokerage, I should say, is not one of the parties on the contract. So if you have here's where we're seeing it more. Most of our agents know that because I kind of lecture on it a lot, and I apologize. A lot of other companies will present it that way, and it's most of everything that I talk about is not going to be the problem until there is a problem. It's not going to cause it; it's going to make it worse. So you just want to make sure you have everything compliant. Brokers are the licensed South Carolina brokers in charge. They're associated real estate licensees and they're subagents, which subagents should be changed to, which is basically a transaction broker. This basically covers in the contract and any connecting documents that where it says broker can be signed by you as the agent. However, if at any time, particularly for those of you that are either not necessarily new in the business, but even new to Keller Williams, let me know should you have any questions specifically about all of these. We run these repetitively for this reason. This is why everybody says, well, you're going to change the topic or the form. Next week we will do, because we've got 2 weeks of free for all this month. We will be able to cover other forms. Trust me when I tell you, there are enough questions that come from this form right here from agents of all levels. We can't go through this form enough. So just something to keep in mind. Closing attorney is a licensed South Carolina attorney selected by the buyer to coordinate the transaction of the closing, right? This is the one selected by the buyer. Seller does not have to have the same attorney represent them. And we are starting to see more attorneys locally not want to represent both sides. Not a lot of them, but some of them. And if that's the case, the seller could just choose their own attorney. This is not a voidable part of the contract. If someone submits an offer and does not have this filled out, that does not void the contract, okay? Effective date is the final date upon which the parties to negotiation place the final and required signatures, initials, and date on the contract, and delivers notice to initially cause this primary contract to be binding on all parties, right? So it's when you deliver notice, and notice is defined later as however it's sent to whatever address is on here as the agent and or party email address. So Jennifer and I are negotiating something out. She submits an offer. I submit a counter offer. Her buyer signs the counter offer, but has not put me on notice. It is not ratified until she sends the notice back to me to say, here is the ratified contract. Okay, so just keep that in mind. It is important to know, and we still see it, particularly in a market like this, if you do not have a signature on a page, you do not have a contract. It's just that plain and simple. And we've seen it a lot before. We're seeing it more now. Yes, Jennifer, they're going to take $350. I've sent it off to them. They're going to sign it. We got a deal. Awesome. Jennifer go tells her buyer. Her buyers are super excited. I get a cash offer for $375 10 minutes later. My seller says, well, we haven't signed this one. I say, well, I gave Jennifer my word. Seller says, love you, love Jennifer, don't care. I didn't sign it. It's not bound by South Carolina law, and they are correct. So you just always want to make sure, Jennifer, I had that conversation with Jennifer. Jennifer can relay the conversation with her buyer to say, listen, they verbally have said, yes, we are waiting on signatures. Until we get the signatures, we don't have a contract. Okay, just communicate that with them. We're doing everything we can. Good funds is the transfer of required money in United States dollars. That really only applies to obviously the purchase price as well as the earnest money. Time is all time shall be calculated at South Carolina local time. Time is of the essence, which means the contract stipulating time deadline and performance period do apply. If you do not hit if you do not hit a contingency or whatever it may be by the time specified, you're out. You're either out basically by breaching the contingency, or the contingency is over, or the expiration is over. Just basically saying that time is of the essence. Buyer and seller is or is not. Buyer seller is a South Carolina real estate licensee. That just has to be licensed. They don't have to be practicing. If they've got their license and referral, then that is a licensee. And then next is where they initial that you have given them the South Carolina disclosure of brokerage relationships, and they're either receiving a client or a customer service in the transaction.
Did this section, this looks new from the first time I did this to the second time I did this. Did this replace that big long extra page where you checked off transaction broker, buyer's agent on the last page?
Yeah, the old contract had that, but that's been a little bit. Now,
Okay.
if you may be referring to the land contract, the land contract did have that on that last page.
It did. And I just did another one 2 days ago, and it was like this one you're showing us. So it must have changed.
Well, this one, you did the land one a couple days ago.
Yeah.
Yeah, they updated the land one on May 1 or May 15th.
Okay.
So if you had one prior to that, it didn't look like this. If you had one after that, it did look like this.
Yep. That's what happened.
Yep. Again, in this situation, everybody always asks, should I go with dual agency? It's not your choice. It's a discussion to have with the clients or the customer, right? So, if I've got a listing and I get a sign call and Carrie comes in and says, hey, I'm buyer, and I don't know you at all, and I want to put an offer on here, I sit down with Carrie and say, hey, here's the South Carolina Disclosure of Brokerage Relationships. Here's the different levels of service you can provide. Which one would you prefer? If they say, I don't really know, I'm not, I kind of wanted to do, I don't need an agent or whatever it may be, you don't need to push to represent them exclusively on there. You at that point can simply say you are entitled to pursue this as a where I basically represent the transaction as it relates to you. Okay. It doesn't always have to be a dual agency situation on that. All right, purchase price. This is where you talk about the good funds that are going to be given for the purchase of the property. It can be done one of three ways: all financed, a combination of financing and cash, which is most of them, or cash, right? Obviously 100% financing probably is not a lot right now. So most of them that you'll get would be a combination of financing and cash. Verification of cash available for closing either is or is not attached or to be delivered before. If I'm a buyer's agent and I'm either making an all cash offer or an offer that's 50% financing, 50% cash, I probably want to put a deadline in here. Hey, I'll give you proof of funds by the end of the day and 2 days from now. You can put whatever date on there, and if the buyer doesn't want to send. If I'm a listing agent and or the seller and I get this offer and it says it's, combination of cash or all cash, I am going to want some sort of verification of funds. And that's not a lot to ask. This next sentence: this contract is or is not contingent upon the sale and closing of a buyer's real property. That's the first part. And then SCR 504, which is probably what we're going to cover the next contracts class because it's a complicated one. It's got, well, it is and it isn't, but they've changed it. Is or is not attached. So two parts of this contingency. The first part says, hey, I'm purchasing your property and I have to sell a house in order for that to happen. And then second part is I've attached the SCR form 504, which basically walks through the conditions of selling my house. Is it listed? If not, when, by whom, and when it needs to be under contract. As a buyer, I'm not super concerned with whether or not 504 is on there, conceptually speaking, because it just limits me. However, it doesn't hurt to have it on there so we all understand. As a listing agent or seller, I would never want to, I would not ever encourage, I would advise, but I would not encourage them to accept a buyer's contract that is contingent upon the sale of a home without having form 504. Because if you don't have that form, you're basically saying, I've got up until the day of closing of this contract to close on my house. And even if 10 days out, I don't have a contract, everyone knows it's not going to close. They don't have to release this because it just says all I have to do is close on my house by that day, which is one of the reasons they corrected 504 to add contract date versus just closing date. Okay, so handful of different things with paragraph 3. Any questions so far? How's everybody doing? All right, good. Section 3, this talks about the property. The property is seller will sell and convey, a buyer will buy for the purchase price any and all lot or parcel of land, appurtenant interests, improvements, landscape systems, and fixtures in any thereon and further described below property, which would be the property address down here. Seller agrees to maintain in operable condition the property and any personal property conveying in the same operable condition, including any landscaping, grounds, and agreed upon repairs or replacements from the effective date through closing, subject to normal wear and tear. Okay, so basically what this is saying is you purchased the property as it is right now. Obviously, you're going to have it inspected, but it is my obligation as the seller to maintain the property from its current condition through closing. So that's just something to keep in mind. When they get a contract on the house, they still have to maintain their landscaping. They have to maintain, this time of the year, they got to keep power on in the house. You can't just let a house go in Charleston without air conditioning running right now. They have to maintain the property. Buyer acknowledges the opportunity to inquire about owners association issues, common area issues, condominium master deeds, assigned parking, membership, lease issues, and finance equipment prior to signing the contract. Okay, so when this, I was to take this off because this means it's a serious discussion, right? So prior to signing the contract. So let me do one quick thing. I think I can. I'm not positive though. Yeah, okay. I put the PDF in the chat box, so you guys can download it. By the way, I realized I didn't do that in the beginning. Sorry about that. Technically, how this is written, and again, these are contracts that are written by human beings whom are not perfect. Technically, what this says is that the buyer acknowledges the opportunity to inquire about owners association issues. You cannot get any more broad than the term issues, right? So technically what this says is if you're purchasing in an area that has a homeowners association, you really have an obligation to do research on that association prior to going under contract, okay? Now, if you're doing due diligence a little bit later, it's a non-issue because you can look during due diligence, right? But if you're not doing due diligence and you look in and you find out that there's some issues with the, the condo complex or some stuff that the reserves are too low, or there's projects that are possibly in the works, and you didn't do your research ahead of time, your buyer could, or the buyer didn't do research ahead of time, they could have a potential issue there. Now, this is separate from a disclosure thing. If there's a pending assessment that was not properly disclosed in the seller's disclosure, then the buyer could argue it should be disclosed, right? But what this does say is that you need to find out how the association works, and this applies to with renters, what the what the renter issue may be, how much they allow in there, that sort of thing. So just something to keep in mind if someone's moving into an area with an association, particularly condos or townhomes. You want to make sure you get as much information on that as possible, or negotiate for due diligence so you can do it during the due diligence period. All right, so jumping back into the contract, going down to the bottom of section 3, this is where the actual property description is. In a perfect world, you've got a deed, you've got all these. In the everyday world, you're going to have the address, the unit number, city, zip, county, tax map number. Those would be the most important things. If you can get lot, block, section, phase, that'd be great. What you do want to do is make sure that the tax map number matches the address. So don't just take it off of the MLS, double check it with the tax records there, and then also just make sure everyone knows. The other thing to keep in mind, in the event you have any sort of assemblage, or one thing we did, excuse me, one time was we had a condo that was selling with a garage that was a separate TMS number. You want to make sure that they're either both in there or a separate contract for each, okay? Okay, section 4, conveyance, closing, possession. Closing occurs when the seller conveys property to the buyer and occurs no later than 5 p.m. on or before this date. So what this says is no later than. Seller has until 5 p.m. to close on that property, which technically means the seller's got until 4:45 to move out. Now, obviously, we don't want to set those expectations. However, we do want to make sure as a buyer, they understand if you want to close early on a Friday, it may be smarter to close late on a Thursday. Because if they come back and say, hey, we can close at 9, and the buyer and the seller is like, I can't be out until noon, the contract protects the seller. Okay, so just keep those in mind. Conveyance shall be free, simple, made subject to all easements, reservations, rights of way, restricted covenants of record, provided they do not make the title unmarketable or adversely affect the use value of the property in any material way. And all the government statutes, ordinances, rules, permits, seller agrees to convey marketable title with a properly recorded general warranty deed free of encumbrances and liens, except as herein stated. Obviously, that would not apply because you're not going to add any, unless there was maybe a transfer of liens of if you happen to, the only area I can think of where this would be effective is if they had, what are they called? Think of power, solar panels, and they had a lease on there and they agreed to transfer the lease over to the new property. So that's just something to keep in mind. The deed shall be delivered to the closing attorney's designated place on or before closing date, no later than 10 a.m. Seller agrees to pay all statutory deed recording fees. This is where they need to know this is where they do pay the deed stamps. Parties agree the broker shall have the access to the closing and relevant documents. Parties agree to hire a licensed attorney. Seller may convey possession of a vacant and reasonably clean property, free of debris, along with all keys, codes, any remote controls, available documents. Give some examples and similar ownership items to buyer at closing. Now, convey possession of vacant, and along with keys, codes, and they have. Now, this reasonably clean property that is not professionally cleaned That is not broom swept. That is not wiped down. It is reasonably clean. So if I were to ask you, Jennifer, please define to me reasonably clean, what would you say?
I would say, you know, if I were cleaning my own house, I would sweep, I would dust, I would get all the trash bags out of there, make sure there's not junk in the closets still.
Right. And that's because you're a normal human being. And that's not what we deal with. So the point on this is reasonably clean is in the eyes of the beholder. So you just need to let your buyer know, if you know their personality, hey, reasonably clean. And you'll know, by the way, when you look at the property, I mean, you know, you're reasonably clean people versus your, oh my gosh, we need to make sure they have this place cleaned. Okay. Now, what happens is somebody gets there and they've left some stuff in the fridge and they've done this and done that. Someone says, well, I'm not closing until they clean it. Well, the problem is reasonably is in the eyes of the beholder. And there's no contractual obligation of what level reasonably means. Now, free of debris, you could argue that. Okay. All right. Any questions about section 4? Awesome. Earnest money. So earnest money, there is no required minimum. Actually, earnest money is not even required for the contract. Okay. A lot of times what we see is around 1%, 2% locally. $300,000 house, $3,000 earnest money. That being said, my wife, Lynn, for those of you who haven't met her, she is a buyer's agent. All she does with our business is work buyers. Her philosophy on earnest money is as little as I can get away with. Because even as clear as it may be that someone defaults on a contract, earnest money is always, I repeat, is always at risk of not being returned. Okay. I don't mean to sound like Debbie Downer or the sky is falling on that. And I kind of want to sound like Debbie Downer and the sky is falling on it, because there are situations where it is clearly obvious that seller defaulted or buyer defaulted, and they don't see it that way, and earnest money gets held up and someone then is PO'd because they thought this is their money they would just get back. Or where the buyer's defaulted and the seller's upset because they think earnest money is punitive. It's not punitive, right? It's a deposit saying I'm going to perform on the contract, but nowhere in there does it say, should they default on the contract, I automatically get the earnest money. Okay, so we just want to make sure we explain that clearly. Earnest money can come one of two ways: with the offer, or within a certain period of time of the offer. Actually, I should say one of three ways, or a combination of both. You have the total in the first line here, and then you have X amount accompanies this offer, and then X amount will be paid by 6 p.m. on blank date. It is in the form of check, and that's the only option. Do not turn in earnest money in cash. No attorney likes it. You can do wiring. There are some local real estate attorneys that are now taking wiring or are paying online. Buyer and seller authorized blank as escrow agent. Keller Williams does not hold earnest money. So at this point, you can choose to have whoever the buyer's attorney is going to be, which hopefully they would know at this point, because you would have selected that on the first part of the page. Again, escrow is regulated by the state. There's no, a lot of people, we've got clients and even some agents that are like, I don't know if I want Carolina One holding my earnest money. It's protected by the government. It's not, they don't go put it in a slush fund or anything like that. They're bound. This is one of the reasons many companies are getting away from it. It's because it's such a highly regulated accounting process, which it should be, because it's the buyer's money, right? So it's held in escrow. Parties direct escrow agent to communicate reasonable information confirming receipt and status of earnest money upon broker request. So if we've got a required document in the in compliance that states confirmation of receipt, that can be a PDF of an email, it can be a scanned receipt, whatever it may be. The next part is one of the first places that a client or a party of the contract can unilaterally terminate, and that's if the earnest money is not delivered by the agreed upon dates above. The seller does not have to, may terminate the contract by delivering notice of termination to the buyer. So if Jennifer puts in an offer and it's supposed to have the earnest money by yesterday at 6 p.m. and they have not, then I, as the seller, can say, hey, I'm terminating because I don't have your earnest money. Now, if I do that, Jennifer can't come back and say, oh, sorry, I forgot. I'll bring you cash right now in a gold-plated box. Seller can still opt to walk. So it's a unilateral option at this point. Just need to be careful on that. From a listing agent standpoint, let's say something happens. We just had this recently. The earnest money was due Friday, this past Friday at 6. There was some confusion. The buyer thought they were supposed to make out the check to Keller Williams. So they made out the check to Keller Williams. When they dropped it off, the attorney was like, hey, we can't take it because it's made out to Keller Williams. So they had to wait until today to have a new check cut for whatever reason. Okay, at that point, the seller had the option to terminate the contract. Now they opted not to because it's literally over the weekend. They're going to bring their money in. They already brought a check. So it was kind of a gray area. This whole bold area right here basically says in big screaming letters that the parties understand and agree that under all circumstances, not some, not a few, all circumstances, including default, meaning including Jennifer can get to the closing table and say, Carrie, I think your house is ugly. I don't want it anymore. And walk out. Carrie be like, cool, I got my earnest money. Not how it works, right? Under all circumstances, including default, escrow agent will not disperse earnest money deposit to either party until both parties have executed an agreement authorizing this disbursement, or until a court of competent jurisdiction has directed a disbursement. Okay. Now, again, you don't want to be too alarmist, but you don't want to be in a situation where people are like, fine, I'll just take their money. Or fine, I'll get their money because, or I'll just give them my money. That's the other thing too, by the way. Default, well, we'll come back to that. All right, questions about earnest money? All right, section 6. This is really more of a disclosure section. The section talks about what the transactions costs are for both the buyers and sellers. Gets into the details on there. It's good to it's good to know this because we have had, again, as part of your buyer and or seller consultation, it would be good to walk through a contract. Maybe even set up a after meeting after you get the agreement and say, hey, I know this doesn't sound like a lot of fun, but I'd love to sit down with you and go through the purchase and sale agreement. The reason is when you have to make an offer or when you are going to receive offers, you're going to be in a highly competitive situation. So I would prefer to us to sit down in an emotional free zone and me kind of point out all the parts of the paragraphs of the contract for you, just so you're not surprised and I can go through them quickly. So 6, transaction costs. Buyer's transaction costs include, this is a good place to say, Mr. and Mrs. Buyer, these are all things that are going to come from you purchasing a house, resulting from selected financing, meaning prepaid recurring items, insurance, including but not limited to mortgage insurance, title insurance, flood, and hazard. Discount points you might have, interest, non-recurring closing costs, exams, FHA, VA, expenses of attorneys, allowable costs, contractually required real estate broker compensation, which if you don't have would be an issue, and the cost of any inspector, appraisal, or survey. Mr. Buyer, what I would highly recommend is that we make sure we have a clear CD from your lender that maps all these out so you understand what that looks like. This is one of the first areas that you start to embrace and engage the entire team versus Jennifer, the center of knowing all, right? She is the center of knowing all, and the reason she is because she surrounds herself with a team. Then you go to the next part. Carrie, Mr. Seller. Seller's transaction costs include deed prep, deed recording costs, deed stamps, taxing recording costs calculated based on the value of the property, all costs necessary to deliver marketable title, payoffs, satisfactions, mortgage, property taxes prorated at closing, contractual required real estate compensation, and fees and expenses of the seller's attorney. Mr. and Mrs. Seller, here's a copy of a net seller sheet. Got most things in there. The things that are not in there are going to be your payoff because I don't know what that is. And if you are comfortable, I could say, you want to get the attorney to verify this, but I'm looking at your property taxes from last year, and it looks like this year that, if they were the same, we're closing about halfway through the year, so it'll cost you about half that. Put those in there, commissions, home warranties, anything in there. The next part is where you bring in the negotiable part of it, which is all costs to obtain information from a pertaining owners association, or this is the first part of the negotiation. All costs to obtain information from or pertaining to owners association, private and public transfer fees, and any costs similar to transfer fees, either certificate of assessments, which are basically a notice of standing from the HOA, capital contributions, which basically means, hey, welcome to the neighborhood, you're going to pay a certain percent. Working capital, which is kind of the same thing. Estoppel fees. Estoppel fees will kind of go towards the certificate of assessment. Sometimes they will have fees for the buyer, or otherwise named, but similar fees are either the seller or buyer's transaction costs. This is the first part of negotiation. From a buyer standpoint, obviously you want the seller to pay for it. From a seller standpoint, you probably paid all these when you moved in, so you want the buyer to do the same. It is important in this situation. I always talk about bandwidth when I talk to my clients about negotiating. One of the areas that can get you in trouble in this is on the seller side. So you get an offer and it's strong, except this part here, and it says, well, they're telling you to sign any contribution or to pay for any contribution fees. Client says, well, I mean, I've lived here for 10 years and I mean, I know all about the neighborhood. I didn't have a contribution fee. I don't really care. So let's just leave it as is. What they didn't know at the last HOA meeting is they voted in a capital contribution fee. Come to closing, there's an additional $2,500 on there. Now the seller's mad, even though, you know, you said, hey, you were fine with it. So just another area that you may want to find out ahead of time, just get a question from them. Are there any capital contribution fees? So you know that when you get to negotiations. All right. And then the next part for negotiation, at closing, seller will pay buyer's transaction costs not to exceed X amount. This is a dollar amount, not a percentage, right? So if you're, you know, your $300,000 house, you're asking for 3% at 9,000. If you get into negotiations, just make sure you negotiate the actual amount of the fee, because if it's a percentage, it's not a percentage and it won't adjust accordingly. You also want to make sure this is another time to get into dialogue with the lender. You get a buyer that comes in and says, hey, I want $12,000 in closing costs. You need to make sure they can use $12,000 in closing costs. Now, a lot of lenders will say, yeah, if there's anything extra, I'll put towards prepaids, et cetera, et cetera, et cetera. Well, you need to make sure your buyer understands that. We had one within the last couple months where, you know, there was some issues with the yard or issues with something that was minor. We'd already negotiated transaction costs, and they wanted to add an additional $3,500 because the loan was going to use it for new carpet. But we put it in there as transaction costs because there was no other place to put it. Well, they had already exhausted the amount of transaction fees that they would allow, so they put the rest of it towards buy downs and prepays, which still benefited the buyer at a high level. However, the buyer thought they were getting an extra $3,500 just contributed to them at closing, and therefore bringing that amount of money less, and they were not, because they weren't able to based on the restrictions of that lending. You just want to make sure you kind of are familiar with that, but not taking the lead. Make sure that you know, in this case, I would say, Carrie, these are great questions. Let's reach out actually together to Jennifer, the lender, and say, hey, here's what we're asking for. If we ask for these, do we get that many, or do we get that much, I should say. Unless otherwise agreed on in writing, buyer will pay buyer transaction costs and seller to pay sellers. All right, 2 pages in at 40 minutes. The rest of it goes faster, don't worry, until we get to section 8. All right, financing. This is where they're going to put what the type of financing they're getting. Contract is or is not contingent upon financing. Now, there's a difference between disclosing that you are getting financing and whether or not it was contingent on financing. I know that sounds weird, but there is a lender. I don't remember who it is, and I don't know if they're just local, but this has happened local, where they're going out and they're telling buyers, hey, we are so confident in our loan, write your contract not contingent on lending, and in the event we don't get it closed, we'll pay for the earnest money as well as any extra expenses that the buyer or seller may have incurred. Sounds like a no-brainer until we go into the fact that if you don't make it contingent on financing and then you don't close because of financing, you are in default. And it's not just your earnest money, and it's not just possible repair costs that the buyer or the seller could be exposed to. So just be very careful of that putting it not contingent on there, it opens them up to more. It talks about whether or not it is contingent, 30 or 15. At reasonable prevailing market terms with loans equal in amounts to a maximum of blank % of the purchase price. And so if you get 95, 100% on here, you might want to double check on what's happening on that. Financing contingency expires at closing. Financing period. This is the first place you need to highlight for your seller. Financing contingency expires at closing. Buyer must make timely good faith efforts to apply for and obtain financing while refraining from contrary actions, meaning they don't go out and buy cars or lose their job or quit their job. In timely manner, buyers shall inform seller and brokers of pertinent financing issues and authorize buyer's lender to disclose pertinent loan information to sellers and brokers. By the way, this is a lot of people get really upset if like the listing agent and the lender communicate. It says right here that that the buyer shall inform sellers and brokers of pertinent financing and authorize buyer's lender to disclose pertinent loan information to sellers and brokers. So they're allowed to do it per the contract. Now, if you're a listing agent, I wouldn't necessarily go behind their back to the lender and say, hey, I want to give you a heads up. I'm going to give a quick shout out to Jennifer, the lender, just to ask some questions. Now, if they push back, and you at that point can say, well, I appreciate that. And per the contract, I'm going to reach out because my buyers are getting super, or my sellers are getting super nervous. Buyer shall apply for financing by blank date. This should not be more than 1 or 2 days out. If they are not at a place where they cannot fully apply for a loan, they don't need to be looking at houses right now. Maybe 3 or 4 days. And shall deliver notice to seller of reasonable pre-final loan approval, either a pre-approval letter or initial approval letter. This is kind of what we used to submit with the offers. Most of this is kind of done by this point. It contains no unreasonable credit, income, or asset conditions by a certain date. So basically, they've done everything that they need to without any unreasonable conditions by a certain date. This can be a couple weeks, can be whatever. A lot of buyers will try to put, by closing date here. Honestly, it doesn't matter. If I push back as a seller's agent to 2 weeks from now, they could probably get the pre-final loan approval within 2 weeks. The next sentence is what seals the deal. Final loan approval occurs when the lender funds the loan. So between that sentence and this sentence, you basically have, we can do everything we can. And as long as the buyer doesn't do anything to mess the loan up, if you don't have the funds by closing, your financing contingency is still in place until closing. Okay. If the buyer changes their lender during the financing period, they must notify the seller in writing within blank calendar days. This next part is it's a little controversy, but quite honestly, it's redundant. It says absent written approval by the seller, the buyer cannot change lender if the closing date agreed upon in paragraph 4 will change as a direct result. Well, that kind of goes without saying because they can't change the lender, they can't change the closing date without the seller approving, right? So this isn't really anything new, to be honest with you. If you knew you got a new lender that said they needed additional 10 days, you're going to go to the buyer and say, or the seller and say, hey, I need an additional 10 days. However, because it was added in there, it makes it a lot more hard to go through and say, hey, we forgot to tell you we changed lenders 2 weeks ago, and now they're telling us it's going to take longer. Well, sorry, you had within so many days to let me know that, and I don't have to claim to change the date. Now, what it does not do is it does not give at this point circumstance to say if they did change lenders and you find out later, there's no condition in here to say, well, you didn't tell me, so I get to terminate. However, if you're notified of the inability to obtain financing during the financing period, either party may terminate this contract by notice. So let's just play this out. This is why it's very important to explain time is of the essence on the closing date. We're 2 weeks before closing. Lender comes in and says, hey, I can't close on July 1. I'm going to need more time. I'm going to write back and say, as the buyer's agent, say, hey, this paragraph right here, if I notify them that you are unable to close during the financing period, they can terminate. Okay, that's a big one. So don't mess around with, and listen, I'm always about communication ahead of time, but you need to not mess around and you need to go to the lender and say, listen, simply by us telling them gives them a possible way to get out of the contract. So you need to be very careful not to do that. I just realized I'm going to send that out as a broker minute. I'm going to make that a broker minute when I get done here. Look at that. Y'all inspired me for cinematic genius that you'll see later today. All right. And then the rest part is lender lender is blank. FHA, conventional, VA, either seller financing. If it is FHA or VA, an addendum either is or is not attached. You would want to have that attached just so everyone has an understanding of what that may include. All right. How's everybody doing? I realized I was going through this and didn't start sharing my screen again, so hopefully y'all are following. All right, let's go to repairs. I'm going to go jump back on the screen for this one. Okay, so repairs. You can check only one of the following options if no boxes are checked, as is what the default is. So we're going to start there. So I can start, and I'll probably end there too, and scare you into never using as is. Now, as is has been told to me by an attorney, not in the best interest of either party, which one would argue, why is it not in the best interest of the seller? And the argument is because even so, no seller is going to argue, well, yeah, I didn't know that there was a nuclear power plant underneath my house either, but you still have to buy. That's pretty much what as is says. As is, as it says here in the contract on page 4, is all parties agree the party sold as is. Buyer buys the property for the purchase price, seller maintains the property subject to normal wear or tear without repair or replacement, and sells the property for the purchase price unless otherwise agreed upon in writing by parties in this contract. Buyer retains the right to inspect the property by a certain date for informational purposes only. Sellers are under no obligation to remedy any issues the buyer discovers during the inspections. And this should be bold, highlighted, everything. Buyer may not terminate the contract based on the results of any inspections conducted. The reason that I'm a little obnoxious on this is because a lot of people throw out the term as is, meaning I'm just not going to fix anything. The buyer's like, that's fine, I'll still buy the house, I just want to get it inspected. That's not what this means. This means, sure, you can buy the house and get it inspected, but literally, unless they were failing to disclose this and you knew they knew, which is an entirely different battle, you could go buy this house as is, you could go in there, it could be falling down, you could be okay with all that, and then all of a sudden, C-17 comes in and lands, only clearing the house by 7 feet because you're at the end of a runway you didn't know was there. And the reason you know it was there is because there was a sinkhole next to it that was hiding it because of a nuclear power plant underneath it. You get the point. There's no way you can get out of the contract as it relates to this. Now, could they argue for it and try to win it? Sure. It just is not a good way to go on either party, particularly the buyer side. Okay. So now we move back up to say, what do we have as an option? Well, the second option that's on here is due diligence. Due diligence basically says during the due diligence period, which begins on the effective date and expires on blank, which is roughly about 2 weeks to 10 business days more. Any extension must be made in writing. During due diligence, the buyer may take prudent steps to help inspectors, sellers, estimators, and realtors all have adequate time for the buyer to coordinate inspection, repairs, seller to obtain estimates, and buyer and seller to negotiate repairs, and buyer to potentially timely, properly due diligence terminate or buy. Okay, so what all that fancy stuff just said is you've got during the due diligence time to inspect the property, tell the seller of anything you want them to fix, decide whether or not you're happy with their answer, and decide whether or not you want to move forward. I tell my sellers during due diligence, here's the good news, you've got a great contract. Here's the other news is until due diligence is over, don't pack anything. Because the buyer can get out. It is their time to inspect the property from top to bottom. Good news is there's typically no gray area. They're going to ask you for things, you're either going to agree to do it or not. And there's nothing like, hey, this is required, anything's required. You don't have to do anything, but they don't have to buy it for any reason. So just keep that in mind. This basically spreads out or just kind of sections out everything that we just said. They conduct an inspection, they deliver a repair request, they either proceed under the contract, either as is, or excuse me, under an amended contract for repairs as is, or they terminate prior to this date here. They may opt to put in a termination fee. If you want any due diligence actually accepted in this market, you're going to need to put a termination fee. I think a good rule of thumb to start is, what would the cost to carry that house be? Divide it by the amount of time for your due diligence period. Buying a, $500,000 house, you got a 2-week due diligence period. You can look at anywhere from $2,500 to $3,500 a month to carry it, maybe more or less. You get the point. So I'm going to give you a $2,000 termination fee or $1,000 termination fee. The termination fee absolutely goes to the seller when it's terminated. As it's written, they technically write a check with the termination agreement. However, what's typically happening is it's less than what the earnest money was, and they're sending them the release of earnest money. Here's your termination fee. Here is your and then I get the rest of the earnest money back. Now, there are not a lot of sellers that are accepting termination fees right now. Okay, so the thing with the termination fee, or excuse me, a lot of sellers that are accepting due diligence right now. And here's why. So we'll go up to the first of the 3 options, which is repair procedure. This is typically what most sellers are wanting now. The reason they're wanting this is basically repair procedure. If you're taking notes on this, write out next to it, pre-agreed upon repairs. Because that's pretty much what this does, is it says there we have pre-agreed upon repairs. What it says is all repair procedure inspections and requests, meaning they're going to have it inspected. They're going to come up with a list of things that they want fixed. They're going to have it submitted to the seller by 6 p.m. on this date here. Then what happens is any and all requests that are necessary to place the heating, air conditioning, electrical, plumbing, water supply, wastewater to be conveyed in operative condition, to make the roof free of leaks, not be newer, but free of leaks, and to address environmental concerns, and to make improvements structurally sound. Improvements, by the way, that not just the house, structurally sound, should be delivered by the deadline above. Okay, so here's the first part. You basically have until you have until this date. Thank you for the note, Jennifer. Let me know if you have any questions. You have until this date to basically say, hey, here are the things that need to be addressed per this line here. Are all these systems functional, operational? Is the roof leaking? Are there any structural issues? If buyer fails to notify the seller within this time frame, buyer shall have waived any and all rights under the terms of this section. Lender's commitment requires any additional inspections or certificates. These are to be provided by the buyer. Buyer's extent shall have the privileged responsibility to inspect the structure, square footage, environmental concerns, including not limited to these. Okay. And then, upon seller's request, the buyer will provide an inspection report. The buyer will provide, meaning this is an optional. So if you submit this repair request, and the seller says, hey, send me the whole repair inspection, and they say no, they technically can't. The contract says they will provide a copy of the inspection. All right, so we've got a situation where Lori has got the buyer, Carrie's got the seller. Lori and buyer go out, get the inspection, come up with their list of requests. They submit it to Carrie by this date up here. Carrie then has, and the seller has until this date to deliver notice either agreeing or not agreeing to make repairs in the buyer's repair requests. Now, this is where it gets kind of complicated, but not really. The cost of all repairs to heating and all the ones we said earlier, electrical, plumbing, water waste, free of leaks, environmental concerns, and structurally sound, are to be paid by the seller. So if you submit a repair request that has 20 items and only 10 of them are technically required and they agree to do 10, but not the other 10, then the seller has complied with the contract. Okay. If they agree to do none of them and 10 of them are required for the seller to address, then the seller has not complied with the contract. If they agree to do all of them, great, you've got a super nice guy. Now, it does specify seller paid requests do not include home maintenance, flooring, fogged windows, grandfathered coded issues, which includes electrical and safety. If it's functioning properly but not safe, it is not covered. Landscaping, preventative maintenance, cosmetic changes, home improvement, and energy efficiency. If seller agrees contractually agrees to make all the requested seller paid repairs, the parties agree to proceed under the admitted contract. Repairs to any other items are the sole responsibility of the buyer. Okay, so we kind of got it so far. Sounds good. Due on the 10th, reply on the 15th, everything's good. Okay, here's what happens when it's not good. Let's say the seller does not timely respond per above. This is always the one. Or does not agree to make all the seller paid repairs. The buyer shall within 2 calendar days choose any of the following. They can accept the property, they can negotiate a new amended contract, which clearly isn't going to happen because they tried to do that. Or they terminate this contract by notice of termination. If they fail to do any of these within the 2 calendar days, the buyer agrees to buy and the seller agrees to sell as is. Now, here's the challenge with this, is there's a big debate statewide right now is within 2 calendar days of when. See, I read it and it says if seller does not timely respond per above or does not agree to make all the seller paid repairs, buyer shall within 2 calendar days. I read of this here. So it's 2 calendar days of this actual date. The question comes is what happens if this date is the 10th, but they respond actually on the 8th? Where I think, as the contract is written, it should be 2 days from the 10th, I would not assume that. If I were Carrie, I'd go back and say, or if I were, excuse me, if I were Lori and Carrie had responded on the 8th, I would assume the 2 days is from the 8th. And I would communicate that with Carrie as the listing agent and say, hey, you submitted this. We actually are going to use the 10th as our 2 days and get out. You're early at that point, worst case scenario. What you don't want to do is be late, because if you're late, first of all, you don't want to, everybody's always says, well, hey, it's all part of, does this keep kicking me off a share screen? I think it does. If you're late from up here, then you don't want to have that as the debate, right? The goal in this is never to win the earnest money, okay? It is not to win the earnest money. The goal, what would you say the goal of the technicalities of the contract would be?
To clearly communicate so everyone knows very precisely what's going to happen.
100% is to have a mutual expectation and agreement moving forward, right? A lot of people say, well, hey, they've got until 10 o'clock tonight, and if they don't do it, we're going to win the earnest money. That's not the point. I can promise you there's not a seller out there that says, yes, earnest money. That's what I want to do. No, they want to do what? Sell the house, right? I mean, that's why they want to do it. So just make sure, again, at the end of the day, nobody's perfect out there. And for the most part, as long as you keep a good relationship with them, other agents are happy to work together. And in this case, hey, he submitted it on the 8th. There's kind of a gray area whether or not then it's 2 days from the 8th or 2 days from the 10th. I'm going to err on the side of conservative, and I'm going to give it to you within 2 days of the 8th. Okay. That's pretty much it for section 8. All right. Questions about section 8? This is one that probably, if not a daily basis, 3 to 4 times a week, I'm on the phone about on both sides at all levels of production. This isn't no contract issue is a new agent issue versus a producing agent issue versus a mega agent issue versus an experienced agent issue versus a broker issue. I mean, we've got one right now where I've got a great relationship with the broker, and it's one of those where we're both like, I absolutely see your side, and from my side, I don't agree. And it's one of those where it can always be interpreted differently. And unfortunately, that's, when you do have to have either a meeting of the minds, which any attorney who's going to be logical is going to say, let's come up with some sort of middle ground. Taking our ball and going home never ends well. So the reason I say this is for those of you that are new, take this, read it again, and then go fill one out. Go find a house. Go find a dream house. What was that $10 million one that just sold on Sullivan's Island? Go find a dream house, write a contract on it. Send it to me and say, Joseph, tear it apart. Right? Like, what did I miss? What did I not miss? And I'll tear it apart. You'll write me a brand new one with all the corrections that I made, and then I'll see something else on there, right? I mean, it just, again, it's not, and I don't say this is scary because it's not. There's nothing that's, it's not, it's all a process, right? I mean, you want to be smart about it. You don't haphazardly do it, but it's all a process. All right. How are we doing on time? Whew. All right, I'm going to pick up the pace for the last part because, yeah, we'll be good. All right, so section 10 or section 9, repairs or inspections. Basically, section 9 says, hey, I've got the right to inspect the property. They'll make the property accessible for inspections. Seller grants permission to the buyer to connect utilities. That rarely ever happens anymore, so don't worry about that one. Appraised value. Contract is contingent on the property being valued or does not contingent on the property being valued. We've got a lot of contracts being written right now that are not contingent on the property being valued at a certain amount. As long as the lender is okay with the buyer to paying the difference and the buyer is able to pay the difference, they're fine to do that. Wood infestation report, also known as the CO 100 report. You can say whether or not it's contingent on this, who is having it inspected, who selects the inspector, and then they deliver timely, you deliver in a timely manner if any issues need to come up. This is similar to repair addendum in that if the buyer, or excuse me, the seller agrees to address any of the actual issues, then the buyer needs to move forward. If the seller does not agree, the buyer doesn't have to move forward, and the seller would technically, will more than likely lose the earnest or not keep the earnest money. Okay. All right, survey title, elevation insurance is basically a disclosure that says you should have all of this done. I'm going to skim through a lot of these because they're more disclosures. I will cover this second half at some other time. I'm just going to be, I booked back to back in this for an hour, and that was silly to do. Survival basically means anything that was provisioned in the contract and did not happen does survive the contract. That being said, if you're a buyer and the seller hasn't done something, be careful. You don't have a lot of leverage at that point. It says they were going to fix the door. They didn't. Goes to closing. They're still bound to do it, but you probably all lost a lot of leverage. Home warranty talks about if there's going to be one, who's going to pay for it, and then what company it's going to be. Fire and casualty basically says the property's damaged by fire, casualty, other uncontrolled situation. The seller is to be responsible for the damage and repair it, remit to the buyer any funds for repairs, assign the buyer the right to all the proceeds from insurance. If the buyer's inspection caused the damage, buyer's responsibility for indemnifying the seller for the damage. Brokers and parties should ensure that they are protected. Appropriate risk management strategies such as insurance. So if something happens during the thing, that they have the option to repair it. The buyer can accept that. They can terminate. It just kind of depends on the situation. Paragraph 16 talks about whether or not they filled out a property condition disclosure. They should have done so. There is an exemption form, but there's really the only thing on there is if it was obtained by a court order. Never having lived there doesn't count. A rental property never counts, or not living in it doesn't count. They still need to fill it out. Lead-based paint means if it were built prior to 1978, that they will have filled out the form and disclose whether or not they have any knowledge of lead-based paint. If they have any questions about sex offender or criminal information, they have to look it up themselves. Trust account, whether or not they may or may not place deposited earnest monies into an interest-bearing account. I don't know of anyone who does an interest-bearing account, so you can just check off may not. Tax on non-resident means as a seller, if you're a non-resident, you will need to cooperate with the attorney by withholding some requirements of the state income tax. Merger clause basically means all parties agree the contract expresses the entire agreements to the parties. There are no other agreements, oral or otherwise, outside of this. I'm not agreeing to pay you anything outside of closing. I'm not agreeing to pay you any sort of rent. I'm not agreeing to do any of those. Adjustments. We will make all adjustments on the day of closing. So if there's any prorations of any HOA fees, taxes, insurance, anything that goes on there, that'll be prorated to the day of closing. Default gives a list of some things that could happen should the buyer or seller default. This is the first place you want to point them if they're saying, well, that's fine, I'll just give them the earnest money. Well, it's a little bit more to that. You need to talk to an attorney. Mediation means the first place they will go is to mediate versus arbitrate or versus sue each other if there's a disagreement here. Non-reliance clause basically means that they've moved into this freely and voluntarily, not relying upon any of the statements or representation by the brokers. If they did have any legal questions about it, they would talk to an attorney. Broker disclaimer basically says, I'm going to skim over this, but I want you, this is an important one. It basically says, I'm not a inspector, HVAC, electrician, plumber, any of those. That's why we invite all the other people in as part of the transaction. I am a real estate agent, right? I am here to navigate you finding a property, navigate you selling a property, getting you negotiated to the contract, and then taking you from contract to close. Anything specifically having to do with any of these obviously would be something that you're on your own for. I mean, you'd put it more eloquently than that. Broker's compensation basically say that the closing attorney will use the settlement funds collected to disperse the broker's compensation. Attachments or other contingencies in the event you have, say, Form 504 for the home sale contingency, or you've added just a general addendum, or you have something that you wanted on there, you would just reference that here. You just do SCR 504 attached, or SCR, whatever attached. Notice and delivery, we talked about this earlier, it's the unilateral communication of offers, counteroffers, acceptance, terminations, etc. Acknowledgements, basically due to criminal activity, parties solely responsible for verifying all wiring instructions. They also understand that the audio-visual surveillance may occur in a property and they should plan accordingly, and that they should comply with all federal regulations if they're the seller. Parties acknowledge receiving, reading, reviewing, and understanding this contract, the disclosure of real estate relationships, any agency agreements, and copies of these documents. This is when you would put in the expiration of offer, witnesses, signatures. Sorry to have flown through the end, but that is the purchase and sale agreement. Questions off the top of your head? All right, I guess that means not. So, Carrie, did you have one?
No, I'm brand new, so I'm just trying to figure it all out.
That's fine. Listen, this will be posted and they'll be sent out, and there's a whole library of these. If you have trouble sleeping at night, just go ahead and put that on, put you right to sleep. You do not hesitate to go get clients because you're overwhelmed by the contract. I promise you, that is not an issue. We will get you written. We will have you protected. It is not as scary as it sounds. The only reason that I can do this very well is I literally walk through this almost on a daily basis. And you will be you'll be fine. Don't be overwhelmed. All right. Well, if no more questions, you guys have an awesome day. Again, I'm sorry to rush. I should definitely start extending the ones where it's the actual purchase and sale agreement. But we'll get through them all. Keep coming back to these.
Thank you so much.
Of course. Bye, guys.
Bye-bye.
Bye.